You're at work, you're dealing with customers, you've got suppliers to deal with, you're growing your business. All of a sudden, you receive a notification that one of your employees is taking you to the Ccma. What do you do? How do you prepare? How do you defend yourself and your company at the Ccma? That's exactly what we're going to be talking about in today's video. My name is Aslam Mullah and I am a registered attorney. So how do you prepare to defend your company at the Ccma? Do not ignore the notification. If you ignore the notification, it can lead to a default award being granted against you, which means that the commissioner at the Ccma can order up to 12 months of that employee's salary against you, and you'll have to pay that amount. Or even worse, that commissioner can order a reinstatement award against you, which means that you have to take the employee back at work and pay him his back pay. In other words, all the outstanding salary that would have been due to him for him during that period while he was waiting for his Ccma case. Therefore, do not ignore the Ccma notification. It has serious implications for your business. With that in mind, how do you prepare for a Ccma case if you are an employer? Step number 1, check the basis for why the employee referred the case to the Ccma. Is it for misconduct? Is it for incapacity? Is it for retrenchment? The next step is for you to prepare your evidence at the Ccma. The reason why you have to prepare is because in terms of the Labor Relations Act, the onus is on you to start generally, which means that you have to start on the day of the hearing. What kind of evidence should you prepare? If you're dealing with a misconduct case, then you need the charge sheet, you need the disciplinary hearing notes, you need witnesses, you need documents to show that the employee is guilty. If it is a retrenchment case, then you need a Section 189 notice, you need the proof of consultations. If it is an incapacity case, then you need to show the different consultations that occurred with the employee. Either way, be prepared to show that you have followed the procedure and that you have fair reasons for the dismissal. Now, if you did not follow the procedure and you did not have fair reasons, it's not the end of the world. You can look at out-of-court settlements. In other words, you can attempt to settle the case with the employee. You can look at giving the employee a certificate of service. You can look at giving the employee a good referral, and even compensation can be different options that you can put on the table with the employee. Also remember that the case is divided into conciliation and arbitration. We have done a separate video on dealing with objections at the con-arb stage. The important takeaway from this video is, if there is a Ccma case coming up, you must prepare for it. If you fail to prepare, then you will prepare to fail. If you need help in your situation, whether you are an employer or an employee, you're welcome to click on the link below and book an appointment with our office. I wish you all the best, and I'll speak to you soon.